Welcome to today's deep dive. We're really thrilled to have you with us today because we are on a mission.
A very specific mission.
Right. We are exploring a truly fascinating legal problem, one that kind of challenges your everyday common sense understanding of what it actually means to commit a crime.
Absolutely.
We're looking at the legal definition of stealing. So I want you to picture a scenario. Next time you're, commuting on the highway, look at those massive semi-trucks rolling along beside you
Calling billions of dollars of goods.
every single day. Now, what actually constitutes theft from an interstate shipment if the goods never leave the truck? Let's unpack this. If nothing goes missing from the vehicle, if the cargo remains exactly where it was loaded, can a theft actually occur?
It is a brilliant question. And to understand the answer, you and I are going to have to look at how federal law completely rewrites the traditional rules of theft.
Okay.
Our analytical path today is going to take us right into the heart of a 1981 Ninth Circuit Court of Appeals case. That's United States v. Faulkner.
A Faulkner. Got it.
Right. And alongside that case, we're going to meticulously examine the precise application of 18 U.S.C. Section 659. What's so fascinating here is that to really grasp the mechanics of this law, we have to look at how this statute breaks away from the old, strict, centuries-old rules of common law larceny.
Right, because under the Old English common law, theft wasn't just about intent. You couldn't just think about stealing something or merely touch it. There was a physical requirement, wasn't there?
Yes, there was.
The concept of having to actually carry the item away.
Exactly. The traditional legal term for that is asportation. Under the old common law rules of larceny, for a theft to be complete, the thief had to physically move or carry the property away from its original location.
Even if it was just a few feet.
Even for a short distance, yes, it was a very strict physical threshold. But as we entered the era of the modern supply chain, with massive 53-foot trailers and interconnected global logistics, that old rule became a massive loophole. Well, if law enforcement had to wait for a thief to physically remove a heavy refrigerator from a commercial truck before making an arrest, the thief might already be driving away. The authorities needed to be able to intervene much sooner.
That makes perfect sense. The law simply had to adapt to modern logistics. So before we get to the specific case of Mr. Faulkner and see how this plays out in real life, can you introduce the core legal concept for us?
Sure.
What is the overarching law governing theft from interstate shipments today?
Let's lay out the general rule under 18 U.S.C. Section 659. The statute penalizes anyone who, and I will quote the key language here, embezzles, steals, or unlawfully takes, carries away, or conceals, or by fraud or deception obtains from any motor truck with intent to convert to his own use any goods which are a part of an interstate or foreign shipment.
Wow. That is a dense piece of legislation. It sounds like Congress threw every possible verb into that sentence just to make sure they didn't miss a single thing.
They cast a very wide net.
So what does all this mean when we break it down into its testable elements?
You're right to notice how broad that language is. Legally, it breaks down into two primary testable elements.
Okay.
Element 1 is taking over possession and control of the goods.
Possession and control.
Right. And element 2 is having a felonious intent to convert those goods to one's own use. If we connect this to the bigger picture, the underlying policy is all about commerce.
Protecting the supply chain.
Exactly. Congress enacted this statute with a very specific, very broad purpose, which is to aggressively protect the channels of interstate commerce from any kind of interference. They wanted to ensure that goods traveling between states are entirely secure.
Which is why the rule is written to catch so much more than traditional common law theft.
Yes, they aren't just punishing the successful heist, they are punishing the interference itself.
Let's analyze United States v. Faulkner. First, what are the legally dispositive facts?
The facts here are striking. Thomas Edwin Faulkner was a truck driver for North American Van Lines. His assignment was straightforward. He picked up a commercial shipment of 105 refrigerators in San Diego, California, and was hauling them to Hartford, Connecticut.
Okay.
But he stopped in Las Vegas, Nevada. He called an appliance store owner named Richard Erbauer, and he offered to sell the refrigerators to him. Erbauer realized this was suspicious and tipped off the police.
Look, smart guy.
Definitely. Unaware of the police, Faulkner broke his own truck's seals, entered the rear, opened 2 cartons, and rearranged the boxes to exhibit the refrigerators to Erbauer. The deal fell through, though, and Faulkner was arrested as he tried to leave.
And what was the core legal issue?
Was the evidence sufficient to support a conviction for embezzlement or theft from an interstate shipment when the defendant never physically removed the goods from the truck and never actually sold them?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the black-letter rule under 18 U.S.C. Section 659. The rule has two primary elements. First, taking over possession and control of the goods. This does not require physical removal or common law asportation.
Okay.
Second, felonious intent to convert the property to the taker's use. And here, even an intent to eventually return the property does not exculpate the defendant.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, taking over possession and control?
We look at the subrule first. The statute must be construed broadly and does not require physical removal of the goods or common law asportation.
So no carrying it away.
Right. In applying this, the court noted that Faulkner exercised dominion and control by deviating from his assigned route, breaking the truck's official seals, opening cartons, and physically moving the boxes to exhibit the refrigerators to Erbauer.
Just moving them around inside the trailer was enough.
Exactly. The court concluded this element was fully met. He assumed possession and control despite the refrigerators never leaving the truck.
Understood. Now, what about the second element, felonious intent to convert?
The subrule here is that the intent required is simply the intent to appropriate or convert the owner's property.
Oh?
Applying the facts, Faulkner negotiated a sale with Erbauer. This demonstrated clear intent to appropriate the refrigerators for his own financial gain.
Even though the deal fell through.
Yes. The fact that they couldn't reach an agreement and the sale wasn't completed does not erase the intent he had when he opened those boxes. So the conclusion was that the jury was fully permitted to conclude Faulkner had the requisite intent to convert the goods to his own use.
And after analyzing all the elements, what was the court's final conclusion?
The Ninth Circuit affirmed the conviction, concluding the evidence was absolutely sufficient, establishing both the requisite act and intent under Section 659.
I find this entirely fascinating because it's such a massive departure from what you typically see on a television show.
Oh, for sure.
On TV, the bad guys are always physically unloading the illicit boxes into some dark warehouse. If the cops bust them while the boxes are still in the truck, it's usually charged as an attempted crime.
Right, but federal law works differently.
Exactly. Federal law says the moment you exercise control with a bad intent, the theft is fully complete. So I challenge you to illustrate this rule with a memorable, maybe even extreme hypothetical to ensure you, our listener, never forget how broad this statute actually is.
I am fully on board. Let's look at a visceral, unforgettable scenario based strictly on the legal parameters of the Faulkner source material. Imagine a truck driver transporting 10,000 pounds of raw, violently foul-smelling animal manure across state lines.
Oh, wow.
It's for a commercial fertilizer company. The driver decides to go rogue, stops at a local farm, breaks the truck's security seal, and scoops up a single stinking handful of manure to show a local farmer.
Just a handful.
Just a handful. He's hoping to sell the whole load for cash, but the farmer is instantly disgusted by the smell. He gags and he utterly refuses the deal.
I don't blame him.
Right. So the driver drops the handful back into the truck, seals it back up, and drives away.
Okay, so let's look at this under Faulkner in 18 U.S.C. Section 659. This is still a full-blown federal crime.
Yes, absolutely.
The driver broke the seal, he exercised dominion and control over that gross payload by scooping it up, and he had the clear intent to convert it because he offered it for sale.
Precisely. The extreme grossness of the payload doesn't matter. The failure of the sale doesn't save him. And the absolute lack of physical removal of the product from the truck does not save the driver.
Because the elements of control and intent are fully satisfied.
Yeah.
Even though he put the handful right back.
Exactly. The trucking company lost zero inventory, but the crime is complete the moment the interference and intent align.
That paints a remarkably clear picture. It really drives home the reality that the federal government does not mess around when it comes to the nation's supply chain. So let's transition to our final wrap-up. Could you synthesize everything we have learned today into a step-by-step diagnostic checklist for you, our listener?
I would be happy to.
We want this to be an actionable tool for issue spotting in similar legal scenarios.
Here is your structured exam framework for 18 U.S.C. Section 659. Step 1. Check the shipment status. Are the goods part of an interstate or foreign shipment?
The jurisdictional hook.
Exactly. This provides the jurisdictional hook for the federal government. Step 2. Analyze the actus reus, which is possession and control. Did the defendant exercise dominion and control over the goods?
And what's the tip to spot that?
Your diagnostic tip here is to look for broken seals, rerouting of the truck, or rearranging of boxes. Do not look for physical removal from the truck. Asportation in the common law sense is an old trap and explicitly not required here.
Right. Keep the truck in mind.
Yes. And finally, step 3. Analyze the mens rea, the intent. Did the defendant intend to convert the goods to their own use?
Even if they fail to sell it.
Right. The diagnostic tip is to look for negotiations or attempts to sell. Remember that failure to complete the sale or even a stated intent to eventually return the property, like putting the manure back, does not erase the felonious intent.
Thank you for walking us through that framework. And thank you to you, our listener, for joining this deep dive into the fascinating mechanics of federal theft law.
I want to leave you with a final thought to mull over. If breaking a seal and merely shifting a box inside a truck is enough to constitute stealing under federal law, at what precise physical millimeter does an authorized driver's legal transport instantly transform into a federal crime?
It's a razor-thin line.
It is. Does the crime begin the moment the seal snaps, or the moment the thought enters the driver's mind while they are off route? It challenges you to think about how thin the line is between lawful employment and federal embezzlement when physical theft isn't even required.